Good morning and welcome to an oral argument session of the 5th District Court of Appeal. This is our 10 a.m. oral argument, and we have the case of Jason Kubaski versus Patricia K. Stone as trustee of the Patrick K. Stone Revocable Trust. My name is Rand Wallace, and I'll be presiding over this oral argument today. I also have joining us today from our court, Judge Eric Eisnagel from Seminole County. And we also have the privilege today of having Judge Carol Falvey, who is a circuit judge in the 5th Judicial Circuit, currently sitting in Inverness, Florida. And I want to thank Judge Falvey for helping us out here today with this case. And I'm going to assume that, is it Mr. your last name, Duvalier, is that correct?
Duhovny.
Okay, sorry for butchering that name there. But I'm going to assume that you would like 5 minutes of rebuttal unless you tell me differently, and then you may proceed.
Okay, yes, Your Honor, I prefer to have 3 minutes of rebuttal.
Okay.
May it please the court, my name is Michael Duhovny, and I represent the appellant Jason Kubaski. The judgment being appealed contains extensive findings of fact, almost all of which are not in dispute, so this will primarily be an application of the law to the facts. This case involves the assignment of the exclusive right to use a parking space from one condominium unit to owner to another. And these assignments are allowed by law and by the condo declaration, so assignability is not an issue here. It's the assignments themselves. So let me lay a roadmap to my presentation, Your Honors. These are the issues that we'll be addressing. The trial court erred by allowing introduction of parole evidence over objection to declare null and void a complete, fully integrated, and unambiguous agreement. The trial court also erred by not upholding the validity of the assignment based on doctrines of estoppel, waiver, and ratification. The trial court erred in ruling that the statute of frauds applies and that the agreement does not comply with the statute of frauds because it is supposedly not signed, witnessed, and notarized, which is not the case. Your Honors, would you prefer that I provide a factual background, or is the court familiar enough with the facts?
I think we're familiar enough with the facts, so if you could just get to your argument. I know you have 3 issues that you've outlined.
Yes, thank you, Your Honor. Your Honor, the assignment of parking space 50 is clear and unambiguous on its face. It includes a recital of consideration repeatedly endorsed by Florida's courts and an integration clause, which states, this assignment contains the entire understanding of the parties and supersedes all previous verbal and written agreements. There are no other agreements, representations, or warranties not set forth herein. The lower court recognized that the assignment makes no reference whatsoever to any other assignment or extrinsic document. It is a complete, comprehensive, and valid conveyance of the assigner's exclusive right to use parking space 50. It contains no conditions, no contingencies, no incorporations by reference. The assignor, Vincent Stone, he is identified by name in a typed portion of the assignment, executed the assignment by signing it, as did 3 witnesses and a notary public. For years following the execution of the assignment, the parties, all family members, and their successors treated it as valid and conducted themselves as if it were a valid enforceable document. However, the lower court considered extrinsic evidence that was really irrelevant and should not have been permitted over defendant's attorney's objections in its interpretation of the assignment. It deemed the assignment to be 1/2 of a swap of parking spaces made in consideration.
Counsel, your objection at trial to when the parole evidence was offered was simply objection relevance, correct?
To the actual, they were attempting to introduce the other assignment document.
Your argument is, look, that the parole evidence was improper, and you said, and it was entered over objection. I'm just trying to clarify what exactly was stated in the objection. what my recollection from reading the transcript was, the objection was, quote, objection relevance. Is that an accurate statement of the objection?
I don't have the transcript in front of me, Your Honor, but I believe that was a relevance objection to the actual document itself. But throughout the whole trial and in opening and closing, we made the argument that that parole evidence, which is not a it's a rule of contract law, that applied, and that it would be improper to introduce the extrinsic evidence beyond the four corners of the.
Sure, but don't you have an obligation to make a timely objection? In other words, barring a motion in limine that's been granted, right? Don't you have an obligation to make an objection at the time the evidence is being offered?
I felt that I did, Your Honor.
Well, and that's what I'm asking is was the objection at the time the evidence actually came in, was the objection just simply the statement of relevance, or was the objection, Your Honor, we object, this is a parole evidence and it's not admissible? Which objection was made? Again, I tried to find it, and what I saw was just simply objection relevance.
I know that the parole evidence rule was argued and discussed throughout the trial. At the time that.
Yeah, I'm specifically asking at the time the evidence was offered. You don't not remember?
When you say the evidence, are you referring to the second assignment document?
Yeah, frankly, all of the testimony and evidence that you have argued was improper parole evidence. Some of which there was no objection to from my reading of the transcript, but where I did see an objection, it looked like the ones I could find, it was just all that was said was objection relevance. And I'm just trying to find out if I missed something in the transcript, something more specific.
Your Honor, I'd have to go based on memory, and I know that was a big issue throughout the whole trial, was that this was a complete, integrated, unambiguous agreement, and that to introduce other evidence would violate the parole evidence rule.
Well, counsel, I guess I understand that, and I do understand that you argued parole evidence was inadmissible in the opening statement and in closing statement. I guess my question is it your argument that you didn't need to raise an objection at the time that the evidence and or the testimony was actually offered? Was it sufficient to make your argument in opening and closing?
It's an argument dealing with contract law, and yes, I think that in terms of the objections that were made, I felt were sufficient in order to implicate the parole evidence rule.
Could you just make the objection in opening and closing and remain silent during the testimony and the presentation of evidence? Would that preserve the argument you're making now?
I feel that it would, but I do feel that I did make sufficient objections throughout the course of the trial as well. Okay, so the court, the trial court, allowed this other evidence in, and then deemed it to be joined at the hip, so to speak, with another assignment agreement. But of course, they each had complete integration clauses in them, and they said they made no reference one to the other, and there was no contingencies at all. The trial court also held that the assignment was subject to and failed to comply with the statute of frauds. However, unlike a deed, an assignment of a transfer of the exclusive right to use a parking space is not covered by the statute of frauds. The parking space is a limited common element belonging to the association. The manner of the assignment is governed by section 718.106 sub 2 sub b and by the declaration.
Counsel, is the right to possess the parking space owned by the condo owner or by the association?
The right to possess?
The possessory interest, yes.
The right to possess is given to the to the unit owner as an
So
apartment.
why isn't the statute of frauds applicable to a possessory interest?
Because it's not a conveyance of a property interest. It is instead the procedure is specified in section 718.106(2)b, which basically just defers to the declaration. The declaration has a pretty extensive list of requirements of what's involved there, and neither the legislature in that statute nor the drafters of the declaration said that these have to be executed with the formalities of a deed, and they're specifically non-recordable. If it was a title instrument, then it would be recorded, and that's where you would need that. But the declaration says specifically it will not be recorded.
So why did the assignment have spaces for signatures for the assignee, the assignor, and two witnesses?
Well, the drafter, Ms. Stone, the appellee, she said that she found a form and that she copied it. Basically, a form that had been used previously with the association. She basically said, "Do you have any forms for this?" And they said, "Well, we don't have a form, but you can look at a previous one." And so she said that she copied and pasted it. She just used the same form as what was used on the previous one. And sadly, it did not have a line there for the assignor to sign, but the assignor did sign, and the court does recognize that he did sign. And we have cited case law that shows that even if a party signs in the wrong location, if it was the intention to carry out that agreement, then that's going to be considered valid.
There were two assignments, correct? There was one for space 10 and one for space 50, correct?
Correct.
And the one for space 50, was that completed appropriately and fully?
Well, there was no, yes, but we have to take Florida law into account there, because there was no line for the assignor to sign. So he ended up signing next to his name, but he did sign.
In the section that was for 50, we're talking about in the section that was designated for the assignor, correct?
There was a place for the assignor and then no line to sign there. And so he signed where his name appeared. 450.
So he signed, and there was no line for the assignee either, correct?
There was no line for the assignee, but the assignees signed as well.
And were there any lines for the witnesses to sign?
There were no lines at all, from what I recall. There were some spaces, and so Mr. Stone, the assignor, he signed there, and then his wife signed as a witness as well. And
so there was only then I guess technically if in the assignment for space 10, you have, if you're going to assume, you're not saying that Mr. Stone both witnessed and signed as the assignor with that legal effect for the assignment for space 10. Is that correct?
For space 10, which is the one we're saying was irrelevant and should not be considered under the parole evidence rule. But on that one, now when you say Mr. Stone, which Mr. Stone are you referring to? It was a father and a son.
Senior.
Okay, so with regard to space 10, I believe that that his signature there was as assignee or as a witness.
Okay, and then for space 50, Mr. Stone Sr. signed in the space for the witness, not the assignor, correct?
There was no space to sign for the assignor, but yes, if you look at the text surrounding it, it's the witness area. But he signed it, and then the notary acknowledged his signature.
So the assignment for space 50, there was one space that was entirely left blank, which would have been the space in the section designated by type print for the assignor, correct?
The assignment for space 50?
Yes, sir.
take a look. The asinore is identified at the bottom of page 4, and then it carries over to page 5. And Mr. Stone Sr.'s signature is about in the middle of the page. And it's below where it says signed, sealed, and delivered asinore. So it's below that. And then to the left, it says first witness.
Okay.
So we feel that the statute of frauds does not apply in this case, but even if it did, that the requirements, the statutory requirements are met. We feel that the main issue here really, Your Honors, is the plain language of the agreement, because it is very clear and it has no references to to any other agreements, and it was improper to allow the parole evidence. That is very extensively briefed, and there's one section there that I do want to emphasize, and that has to do with the cases that the court itself had cited. I ask the panel to please review those cases very carefully, because they really support the appellant's position as opposed to supporting the court's ruling. And especially when it comes to this issue about saying, well, what's the true consideration? Let's allow parole evidence so that we can determine what the true consideration was. And one of the very cases that is cited by the court is in re Estate of Barry, 689 Southern 2nd, 1186. And that one, I have a long quote in there, but I'll just emphasize this part. Clearly, the parole evidence rule bars claims arising out of prior extrinsic agreements, oral or written, which contradict the terms of the fully integrated document. Nowhere in the document is there even a hint of obligation on the part of appellee. We also reject the applicability of law allowing parole evidence to demonstrate the, quote, true consideration of an agreement. Recognizing a, quote, true consideration exception to every motive that may prompt one to execute a document would truly be an exception that swallows the rule. And then there was another case in here that we had cited where a deed was challenged, and it was just fairly standard language of the deed. But what happened was that
Counsel, you're into your 3 minutes of rebuttal. I don't know if you want to hold on to that time, or
I'll hold on to the time.
Okay. All right, Mr. Whitehead, you may proceed.
Good morning, Your Honors. Alan Whitehead here on behalf of the appellee, Ms. Stone. Judges, the court reached the right result in this case, clear and simple. This was a garage swap that failed for lack of consideration. And the court correctly concluded that the agreements were not clear and unambiguous and were not properly executed in accordance with the requirements of the statute of frauds.
Now, Mr. Whitehead, you said that it was a garage swap. Nowhere in the documents is there anywhere preserved or printed or written that it is a swap of space 50 for space 10, correct?
That's correct. Doesn't say it in the agreement.
Okay.
The extrinsic evidence that came into evidence, the evidence that was actually presented at the trial, some of which, and I believe the only objection raised at trial, I think, is what Judge Eisnagel indicated, which was an objection to relevance as to the assignment agreement for space 10. The testimony regarding the true consideration, regarding the execution of the agreement, regarding all of those issues that the appellant is now complaining about, came in without objection. There were arguments made in opening statements. There were statements made, and in closing argument, there were arguments made regarding parallel evidence, but there was no objection related to parallel evidence. And I don't think that's sufficient for purposes of appealing this issue.
Counsel, I didn't see a standing objection at any point granted. Did I miss it? Was there a standing objection that the trial judge recognized?
No, Your Honor. Not that I recall. And prior to the argument today, I kind of did a word search based on the index of the transcript and scanned the transcript, and I did not see any objection related to parole evidence that was outside of the opening statement or the closing argument. The issue is an interesting issue, is Mr. Dahavni's argument that the statute of frauds doesn't apply because this isn't an interest in land. We dispute that the association owns the limited common elements. The limited common elements are owned by the unit owners in total. All 50 unit owners have an 1/50th interest in all of the common elements. And just like a lease has to be in writing because it deals with possessory interest related to real estate, this document needs to be in writing and it needs to be executed before 2 witnesses and a notary. And it did not do that. The notary provision is where in chapter 698, it talks about 2 subscribing witnesses. And we believe that requires to subscribe and swear before a notary as to witnessing the document. And so the agreements were ambiguous, as the court reflected in its findings of fact as to the ambiguity, and was not properly executed. And therefore, the transfer of garage space 50 was not proper and was set aside, properly set aside. We argue in our answer brief under the what we refer to as and the courts refer to as the Tipsy Coachman doctrine, that if it's not an interest in property, then at best it's a license, and a license is freely revocable. Now, that issue was not pled, or at least it wasn't properly pled in the trial court below. But under the case that we cite in the footnote of our brief, the Dade County case and the Tipsy Coachman doctrine, we believe it's appropriate for the court to consider it because, again, the right result was reached. If this is just a license, then the license ends when the grantee of the license ceases to own the property, or when it's revoked, which was clearly revoked in this case. As it relates to the consideration argument,
that seems like just going back to that, it's sort of an interesting concept, but I sort of question, I definitely question whether the Tipsy Coachman doctrine can be employed in a way to affirm on a grounds that the trial court wasn't even able to rule on because it wasn't pled.
And all I can rely upon there, Judge, I didn't mean to cut you off if you weren't.
No, go ahead. That was it. What do you think of that?
It's kind of cited in the Dade County case, and counsel indicated in his reply brief, we didn't talk about this, but we did. We cited to it in our reply brief, which I'm looking for. It's that footnote, and the Dade County case talks about that, and it says,
even where the grounds was entirely unpled.
It doesn't say that. It doesn't completely say that. But it does say can present any argument supported by the record, even if not expressly asserted in the lower court, which I think we can infer means not expressly asserted in a pleading.
Well,
and we do kind of talk around it. We don't specifically raise the issue of it being a license, but I can't even argue that. It wasn't properly.
I mean, I think there might be a difference between preserving an argument, right, which might be what that footnote was talking about, versus failing to plead, right?
It might be.
Defense altogether.
There might be, but if we look at the overall reason for the Tipsy Coachman doctrine, which is if the court reached the right result, but did so for the wrong reason, then it would stand to reason, at least in my humble opinion, that we should be able to consider that. Or
I'm just not
Your
sure
Honor
that,
should. Maybe I can't argue it, but you can consider it.
I guess to just think of it this way, if the trial court had reached that result that you're asking, that you're advocating, right? Would the trial court, would it have been proper? And I mean, I think there's a pretty strong argument it would have been improper because it wasn't pled.
Yes, sir. We certainly attempted to, we actually discussed it in our trial memorandum. We actually discussed the licensing issue as an alternative, which Mr. Dahavni did object to in his opening or closing argument as it not having been pled. The court never got to it because the court decided that it was a real property interest and made the ruling it did on the improperly executed documents. Your Honor, I don't know the answer to the question. It just seems to me that if the overall goal is to make sure that we reach the right result, I think it's an issue that could be considered.
Your strongest argument is that the statute of frauds, I mean, I'm not telling you, I'm really asking you, I'm intending to make this a question. Isn't your strongest argument that the statute of frauds applies and that it was not complied with?
I think that's a strong argument. I also think, though, that the failure of consideration argument is a valid and strong argument. And I've read the cases that Mr. Dahavni cites in his memo. I've read the cases provided by the court. I think this case, and Mr. Dahavni disagrees with me in his reply, but I think that the case of La Rosa is instructive on this. In the La Rosa decision, which was the 483 Southern Second decision from the Third DCA, which dealt with the leasing of a building for purposes of having a moving and storage business, and then there being later discovered that there is some sort of zoning ordinance that doesn't allow for it, and that agreement fails for lack of consideration, that you can look at consideration, you can look at extrinsic evidence as to what consideration was at issue here. And I don't think the line of cases that Mr. Dahavni cites to precludes that. He relies upon a Supreme Court decision that has a very limited holding, and that is the Chase Federal Savings and Loan Association decision, the Supreme Court decision, which declined to set aside a deed where the consideration was stated as love and affection. And in that decision, they strictly limited the decision to and expressly state, we deem it advisable to caution against too broad an interpretation of our holding. It should be obvious that our opinion does not in any way affect the existing law of Florida, under which consideration is required to support contractual undertakings of any kind, whether characterized as contracts, covenants, promises, agreements, or the like. And it goes on to hold that we don't want to overturn that body of case law that says even conveyances of real property. We're not saying that you don't need consideration and we're not overruling those cases on those points.
And Mr. Whitehead, I'm trying to understand, so your position with regard to the failure of consideration, when it says $10 and other valuable consideration, is it your position that because the rights to space 10 were encumbered by a mortgage and there was a foreclosure, then therefore Vincent Jr. and Christine never had a possessory right to that space because they had a mortgage or it was encumbered by a mortgage, so they didn't have the right or consideration, the value to even assign that away? Is that your position?
Almost. Our position is that because the condominium documents expressly state that if the property is mortgaged, you can't swap your garage. And therefore the garage, any attempt to swap this garage from space 10 from that particular unit was invalid. It couldn't happen. And so what the court concluded, the trial court concluded, was that it was void at the start because he didn't have the right to convey it. And because of that, the owners of Space 50, Miss Stone, or her predecessor, her husband's trust, did not receive any consideration for the giving of Space 50. And that is, that was the court's conclusion, and I believe that's the correct conclusion. And I think it's an issue of, there's a presumption that consideration is valid, but you can rebut that presumption. And the evidence came in sufficient to rebut that presumption. That's our position, unless there are any other questions or any other areas the court wants to explore with me. That concludes our presentation.
Okay, thank you.
Thank you all.
Counsel, you may proceed. And you're on mute, counsel.
Thank you, Your Honor. Very briefly on the license issue, it was not pled. It's acknowledged it was not pled. The court did not rule based on that, and also the rule is that with regard to the issues are framed by the pleadings, and a court is actually, it's not just a matter of choice, it's actually a matter of jurisdiction, that the court cannot rule based on unpled matters. The La Rosa case, Your Honors, is distinguishable because, first of all, doesn't even involve the parole evidence rule at all. That's not a parole evidence case. And that's also a lease. It's a single document signed by both parties, and that is an interest in real property. And it would be illegal. It would have been illegal for that particular use to take place based on the zoning code that applied to that property. So we're talking apples and oranges there. As far as the what Judge Wallace was saying, I mean, the Stone children, or the son and the daughter-in-law, they did have a possessory right, but we have to remember that what this case really is all about is the assignment document of Space 50. And in looking at that, the courts have been very clear that the courts don't want to undo contracts. They want to be able to keep them valid and enforceable. It's an extraordinary remedy to come out and say, no, this is null and void. Okay, especially when there's no wrongdoing, no fraud or anything on the part of Jason Kabaski. He didn't have any notice of any type of claim like that, and so he's an innocent party in all of this. He's a successor. He's a successor to an agreement that inures to the benefit of successors. It expressly states that, and so those. Your Honors, I have only about 30 seconds left. Did Your Honors have any other questions for me?
I don't think so.
Okay. All right, then I'll stop there then. Thank you.
Okay, thank you very much for your arguments. Case was well argued.